We are pleased to welcome you today, Mr. Ronald Meister, to interview with the Cambridge Journal of Law, Politics, and Art. By way of brief introduction, you're currently Senior Counsel at Cowan, Liebowitz Latman, and Chairman of the Board of the National Institute of Military Justice. Prior to this, you concentrated on litigation in federal, state, and military trial and appellate courts. You were also formerly a military judge and represented active duty, reserve, and former military and personnel. Amongst your vast experience, you also offered your legal services at Guantanamo Bay, which is what we would like to focus our interview on today. To begin, in July 2014, it was reported that a Navy nurse refused to continue force-feeding detainees at Guantanamo Bay. You acted as lead attorney for this former Guantanamo nurse. Can you please tell us what prompted you to take on this case?
Well, as you mentioned, I had served as a Navy JAG officer during the Vietnam era as a defense counsel principally and as a military judge. And I had continued my involvement in military justice since that time and to this day, principally as chair of an organization called the National Institute of Military Justice. I have been involved in Guantanamo matters, coordinating an observer program for NIMJ and traveling to Guantanamo. I'd written briefs on Guantanamo cases for the U.S. Supreme Court. When this case arose, I was asked by a retired brigadier general named Stephen Xenakis, who had been involved with an organization called the Physicians for Human Rights. He brought the case to my attention and asked if I would be willing to represent the nurse, which I felt this was the kind of case that my education and experience had prepared me for, and that I would be interested in doing.
And particularly in this case, the nurse faced a potential discharge from the military for refusing to continue administrating force feedings at Guantanamo. How did the Navy explain the complaint against them?
The Navy's not in the business of explaining. The Navy is in the business of ordering. And they wanted the medical personnel at Guantanamo to do certain things, and they're unhappy when they don't do them. To the extent that there was any explanation at all, they expressed a desire, perhaps regarded as a compassionate desire, to prevent prisoners from committing suicide by refusing to eat.
And from your observation of this case, was force feeding a means of discouraging the detainees' protests against their living conditions, or rather an attempt to prevent them from risking death?
There's no doubt they were trying to discourage protests. There's no evidence that any detainee was on the verge of death from a hunger strike, and they wanted to discourage prisoners from conducting what they called asymmetrical warfare. That is, the Navy had the guns, the military had the ammunition, the prisoners had nothing, so they were fighting back in a way with the only tools available to them. And one form of protest was to engage in a hunger strike.
Now, I want to ask you a bit more about the case. Could you discuss a bit about the legal obstacles you encountered when you were taking on this case and how you overcame them?
The principal philosophical obstacle was the ingrained military habit of having orders obeyed. Orders are presumed to be legal, and there's a considerable difficulty to carry the burden of proving that the order is illegal. We also faced a Supreme Court decision from 1950 called Johnson against Eisentrager, which had held that U.S. courts had no jurisdiction over German prisoners of war held by the U.S. outside the jurisdictional limits of the United States, outside the geographic limits of the United States. So the Eisentrager case had been upheld and enforced for At that time over 60 years, and was a presidential obstacle that had to be overcome or distinguished.
Eventually, the US Navy dropped all charges against the nurse. What factors do you think played a key role in this outcome?
Well, they didn't tell us. They're, as I said, they're not in the business of explaining.
Mm.
Uh, we had enlisted the support of some extremely helpful organizations who felt that the vindication of nursing ethical obligations were important. Principally, the Physicians for Human Rights, which I mentioned before, which was a great support to us. We also succeeded in getting the help of the American Nurses Association, which was very vigorous in the support of our client, and who ultimately, at the conclusion of the case, granted him an ethics award, the first one they had ever issued. We got some support to a lesser degree from the American Medical Association, which is a profoundly conservative organization and was less enthusiastic, at least at the outset, than the American Nurses Association, but they did help. And ultimately, presumably as a result of the attention that had been focused on the case, the Department of Defense, which has a ethics committee, a committee on medical ethics, ultimately issued a statement that was in support of our position. So once we had some of that support within the Department of Defense, that was, I think, I assume that was persuasive. A couple of other things that helped us, I think, is first that the nurse himself had an extremely admirable military record. He had by that time over 17 years of service. He had asked the Navy to send him to nursing school, which they did, where, among other things, he learned nursing ethics. And we also never disclosed his identity because we wanted to avoid any possible argument that he was doing this for the sake of publicity or for his own career. And even after the charges were dropped, even after efforts to bar his successful retirement for the Navy were over, even after he in fact retired and started receiving his military pension, we did not disclose his name. So indeed, when the ANA granted him its ethics award, I accepted it on his behalf and ultimately delivered it to him. We used to call him Lawrence Nightingale, but we never disclosed his actual name.
That's interesting because in this example particularly as well, that's an instance where you see that the court of public opinion or the pressure of publicity wasn't really necessary to get the Navy to drop charges, but rather just the internal investigations and the dialogue going on between both sides.
There was a degree of press attention to the case,
Right.
to some degree in the military press and also in the civilian press. So again, while we didn't receive or expect an explanation, I think that all of those factors together persuaded the people who were making the decisions ultimately to drop this case.
And in addition to representing the Navy nurse, you also prepared the brief for the National Institute of Military Justice as amicus in support of petitioners in respect to the Rasool and Bush case. For our viewers, Rasool and Bush was the landmark U.S. Supreme Court case that decided that U.S. courts have jurisdiction to hear habeas corpus petitions filed on behalf of the foreign nationals imprisoned at Guantanamo Bay detention camp on the U.S. naval base at Guantanamo Bay. I would like to ask you a few questions about this brief used in respect to Rasool. Reflecting back now, what do you think was the strongest legal argument in that brief that ultimately won the court over, and why?
There's no evidence that any arguments we made in our amicus brief made a difference to the court.
Right.
There were a huge number of amicus briefs filed in support of the petitioners in the three related cases. They were Rasul and Padilla and Hamdi. And there is no mention anywhere in all of the Supreme Court opinions in all three cases of any of the amicus briefs. We made arguments that included domestic law arguments and international law arguments, and arguments in particular based upon the Geneva Convention, of which the United States is a signatory and which is binding on U.S. courts. None of the international law arguments found their way into the court's opinion. That's not to say that the pressure of some arguments was ineffective. We just don't see that described as the rationale for the decisions in the case.
Following up what you've just mentioned, in particular to the international law arguments, which actually didn't make its way to the ultimate judgment of the U.S. Supreme Court's decision, just drawing upon the point that you made in the brief, where actually you exposed the double standards in the application of the Geneva Convention relative to the treatment of prisoners of war, or the GPW under international law, whereby the U.S. government declared the detainees to be outside the law and that none of the existing rules governing the treatment of individuals detained in combat applied. But then meanwhile, the US expected other nations to abide by international law and extend protections to Americans captured or detained in armed conflict. Just to understand this argument a bit further, what impact, if any, do you think that this double standard has had for the US?
Well, let's talk a bit about what arguments were ultimately persuasive. And you have to read behind the opinions to try to deduce what it was that caused the Supreme Court to come out the way it did. The ultimate factor, I think, is that the idea that Guantanamo Bay was outside of the law, outside of US law, outside of international law, was just too much for a majority of the Supreme Court to swallow. Courts have been telling the executive in the United States for years what it cannot do. That goes back to Marbury against Madison and the Chief Justice Marshall in the early 1800s. It most famously perhaps came to a head in a steel seizure case, Youngstown Sheeton 2 case in the U.S. Supreme Court. So it's not unfamiliar for the Supreme Court to say to the executive, you can't do this. And I think the effort of principally Secretary of Defense Rumsfeld to create a place in Guantanamo that was totally outside the law, domestic law, international law, Cuban law, any kind of law, where there would be no accountability whatsoever, was too much for the court to swallow. So while in Rasul, the case in which we submitted our brief, the court relied exclusively on domestic law, U.S. domestic law, and to some extent its roots in the English common law, that I think when you take the three opinions together, the three cases together, and the many opinions, may have been a bit of cover for a desire to apply some of the standards of international law, though they never said it. And the most important opinion of all of these is Justice O'Connor's opinion in the Hamdi case. Justice O'Connor wrote for 4 justices that there was accountability. She never uses the words Geneva Convention, but she writes an opinion that gives Hamdi and those in his condition procedural rights of the sort that are, I think, equivalent to what are provided in the Geneva Convention, though she never says that. She kind of makes up a structure that she says is applicable, a right to counsel, a right to knowledge of the charges against you. And she just says these would be good things. And we think that as an oversight of the justice system, you ought to be doing this. Well, we have a structure. You don't need to make these things up. We have a document that tells you and has been interpreted to tell you what kind of rights people have. It's called the United States Constitution. And because of that, Justice Scalia, who I think it's fair to say is a more sophisticated thinker, was a more sophisticated thinker on constitutional issues than Justice O'Connor was, he just tears this opinion apart. He says, you're making up a constitution. But it worked for her and for the three judges who joined her, and then for the two other judges that joined the plurality opinion to make a decision in the case. So while you cannot find in the opinion a reliance on international law, you do, if you read it in a certain way, as I do, find that the concepts of international law are what turned the tables in that case. So that's the background. Now, you asked me about the double standard. Other countries regularly point out the hypocrisy of the United States in preaching to them what they can do with prisoners, what they can do on the battlefield, what kind of force can be used. When the U.S. itself is a principal purveyor of torture and is a principal purveyor of massive retaliation, as for example in Iraq. And that decreases this country's credibility when it seeks to enforce standards on others.
You mentioned how Justice O'Connor discusses concepts of international law without explicitly referring to international law. Why do you think there's a reluctance of relying on international law within the judgment specifically?
There's been a long unwillingness in this country to submit its conduct to international oversight and control. It goes back, at least in our modern memory, to our unwillingness to join the League of Nations after World War I. There's certainly been a trend of isolationism in the history of this country, unwillingness to submit to certain international tribunals, and a feeling that we know what's best for ourselves. And but at the same time, we tell other people what's best for them based on our standards. And one of the great exceptions to that was this country's adherence to the Geneva Conventions. And if you look at the background and the rationale of those provisions, much of it is with the understanding that it protects U.S. forces. If we adopt these standards and comply with them, then we have a stronger argument that our forces fighting overseas will be protected. That is a concept that I don't know if it prevails to the present day, and certainly wasn't in the forefront of Secretary Rumsfeld's mind when he says we're going to put people in a position where there are no rules.
You also set out various protections and guarantees codified in the military justice system, including the right against self-incrimination, right against cruel and unusual punishment, or the right to a speedy trial. The detainees went through military courts, and yet none of the detainees ever got to realize these rights. Why?
It's actually not accurate to say that these detainees, and first of all, let's talk about a piece of terminology. The government, the Defense Department, wants to call these people detainees. It's sort of as if they're just waiting for a bus to come along. They're prisoners. They're long-term prisoners. They're prisoners in very harsh conditions. So some people find it preferable to refer to them as prisoners. Whatever you term you use, these are not military courts. These are not courts martial. The rights that we describe in our brief are rights that developed under, most recently, the United States Uniform Code of Military Justice, which has been in effect since the early 1950s. And they're well established. But military commissions are a very different animal. Military commissions are made up ad hoc, and the rules are made up ad hoc. And there was a long, long process of developing rules for these particular commissions that went through several rounds of legislation, several rounds of litigation in the courts, several times the Congress had to go back to the drawing board and start all over again. And ultimately, through those rules, a right of counsel was recognized. There are other rights that are enforceable in military courts, as they are in U.S. civilian courts, like the right to a speedy trial, which are not effective in these military commissions. And you have people who've been waiting trial for over a decade, or over 2 decades, since some of the behavior alleged here took place. So they didn't get, to respond directly to your question, the prisoners didn't get the rights that are guaranteed in military courts because they weren't before a military court. They were before a military tribunal, and we have to recognize that those are 2 different things.
Mm. And in the context of war on terror and Guantanamo Bay, it is concerning to see how clear, coherent laws are disregarded in the name of national security. In your perspective as a former judge, how can we ensure that the checks and balances system will not be interfered with again, as it did for the Guantanamo Bay detainees or prisoners, as you mentioned?
I can only say, as reportedly attributed to Jefferson, eternal vigilance is the price of liberty. There have to be people who are prepared to take up unpopular causes for unpopular defendants. And that has been the case in this country. There are many good people. I know that you have interviewed many others who forcefully stood up for the rule of law. And that is not an easy choice, and was not inevitable in this case. When military tribunals were established first in Guantanamo, the National Council of Criminal Defense Lawyers took a policy position that they wouldn't participate in. They wouldn't defend any of these defendants because it was an unfair, unjust, indefensible system, and they didn't want to be part of it. That position turned, and there were many dedicated lawyers, solo practitioners, academics, large firms, small firms, who took up the cause of providing a defense and making arguments that, in a degree, are the arguments that we're better than this, the country is better than this, the country deserves better than this. And there will always be people who will do that. There have been books written about them. There's a wonderful book called The Guantanamo Lawyers that talks about the efforts that they've made here. And it is also much dependent on the atmosphere of the times. At a time where there are attacks on the United States, at a time where there are thousands of people killed, at a time of any warfare, the courts, like any other institution, are in a defensive posture and do things out of concern for public safety and national defense that, in retrospect, when much of that fear goes away, they have second thoughts about. So we have to be careful to not be entirely in the moment of fear and recognize the historical context, which is a very difficult thing to do.
That was very well put. And that leads into my final question. What legacy would you like our viewers to draw from Guantanamo Bay?
It's a question with many facets to it. It's from the standpoint of my own involvement. Uh, One lesson is what I just said a moment ago, that if we have standards, if we have ideals, if we have processes, if we have rules, then those rules ought not to be easily overcome by fear, by a desire for retribution. And we have to be true to our principles. The Constitution is a wonderful document that continues to evolve despite the view of so-called originalists. It has to change with context, and new situations arise all the time. Guantanamo had some precedents in the establishment of military commissions, not many that were on the scale of this, and not many, though there were in the Civil War and at other times, there were attempts to completely forego the civilian process. And while during the Civil War, the courts were far more willing to accept the exigencies of the military condition, and later came to a more balanced understanding of what's permissible and what's impermissible. But we have rules. We don't need to invent rules to apply the rules in cases like this. And we need people who don't think that they're above the law and what they do is beyond the law.
Thank you, Mr. Ronald Meister, for taking the time to speak with us today to tell us about your legal experiences in respect of Guantanamo Bay and for offering your valuable insights. This has been a great privilege for us and a very fascinating discussion.